Be seated, please. We have one last case on the calendar for this morning. Hare versus State. Counsel, you may proceed.
Please the court. My name is Edward Bauer, and I represent the petitioner, Jimmy Hare. If I could reserve 1 minute for rebuttal, please. The facts of this case are essentially undisputed. During the early morning hours of July 21st of 2007, the alleged victim was involved in a verbal confrontation with the petitioner's friend. This fellow's name was Ron Germinal. All the witnesses agree that the petitioner didn't escalate the situation. In fact, he diffused it, he separated the two men, and kept things from getting physical. At that point, everyone went their separate ways, and the petitioner was seated in Mr. Germinal's vehicle, lawfully a guest in that conveyance, in the front passenger seat. They were approached at the window by the alleged victim, Mr. Harper. At first, according to all the witnesses, things were cordial. They were having a nice conversation. However, the alleged victim, by all accounts, became agitated. He became belligerent to the point where his own friend, Ron Fry, his childhood friend who testified at the hearing, he had to pull him away because he was concerned about his demeanor. Unfortunately for the alleged victim, he decides he doesn't want to be pulled away. He escapes his friend's grasp and, without any justification or consent, dives into the vehicle and attacks the petitioner in this case, who responds by taking his lawfully owned firearm that he had a concealed weapons permit for and swinging it and striking the alleged victim in the head. And at that point, the firearm accidentally discharged and shot the alleged victim in the head and killed him.
There's no dispute as to these facts?
Not as I've laid out, Judge. I think...
I know, but you're going to lay them out in that fight, I imagine. So tell me, do you in good faith tell this court that these are the undisputed facts?
The odd thing about this case is that most of the helpful facts for us came from Mr. Ron Fry, who was, again, did not know the petitioner and was the childhood friend of the defendant. He testified that the alleged victim was agitated. He testified that he pulled him away and he escaped his grasp. He testified that the alleged victim dove into the vehicle and was, he used the word ravished.
Counsel, it seems to me, just speaking for myself, that if you crystallize this case into one central point, it is the State's argument that, I quote from page 11 of their response, the fact that petitioner claimed the shooting was accidental should be a bar to claiming immunity under the stand your ground law. Could you respond to that, please?
If it was a pure accident, if the petitioner had testified the gun was on the seat, he was just sitting there and just went off, I don't know how, and killed the man, yes, because he would not have been exercising self-defense. But what this court has held, and I cited several cases in our petition, in the Mitchell case, I believe, several other cases, what we look at here is an accidental injury does not defeat a self-defense claim as long as the accidental injury flows from some effort of self-defense. For example, the Fowler case from this court from 1986, the alleged victim was a hitchhiker. He was picked up. At some point, the driver, the person who picked him up, threatened to sexually assault him. The driver had a gun. They started wrestling. The gun went off accidentally. This court held, well, he was in the process of defending himself against the threat of the sexual assault. The gun went off because they were intertwined. And that's the word that this court, that's the term this court used in Williams, it's the Williams decision from 1991. As long as the accidental injury is intertwined and flows from some effort by the defendant to defend himself, then the claim is not defeated, that they're logically consistent. And that's what happened here. He was defending himself. He testified, and the court accepted the petitioner's testimony that in response to the alleged victim diving into the vehicle, he picked up the firearm, swung it at his head to hit him, which is an aggravated battery. That is deadly force. He was using deadly force in this case. Now,
but you would admit, would you not, and I don't mean to diminish the tragedy and the severity of what happened here, but would you not admit that your case would be stronger if your client had testified, oh, yes, I held my gun up and I shot him. He was assaulting me and I was defending myself.
That's what's sort of odd about the State's position, that the defendant, almost under their construction of how things should work, that he would have been better off just coming into, oh, yeah, I wanted to blow the guy's head off. But under your
argument, I take it, if your client had testified to that effect, he would be entitled to immunity.
Well, he's entitled to immunity either way, Judge.
I understand that's your argument, too. But, I mean, under your argument, if the defendant says, yes, he came into the car, under the statute, I had the right to use deadly force, and I did.
If that's what he said, I don't see what argument they would have at all. And that's really, they made a few other arguments, but that's really their, as you pointed out, their central opposition to our petition is, well, he said the shooting was an accident, but that's not controlling. The issue is, was he engaged in defending himself at the time the shot went off, and they were intertwined. He was committing an aggravated battery, which, of course, he was entitled to do, swinging at the alleged victim, and that's when the gun went off. So
what about the argument that he was retreating or being pulled out of the car, and therefore the offense, if any, of burglary had been ended?
Probably the most important point that would drive the resolution of this case. The only person who testified about that was Ron Fry, the childhood friend of the alleged victim. And he very clearly testified on direct and redirect that the alleged victim escaped his grasp, dove into the car, at which point Mr. Fry leaned in and grabbed the alleged victim by the waist with the intention of pulling him out. But what's important is, on page 37, lines 18 through 21, Mr. Fry testified, and this is important, so I'm going to read it. I don't want to waste valuable time reading, but I think it's that important. This is what he said. It was just like 2 or 3 seconds before it happened. It happened so fast. And when it did, I had just put my hands on his waist and pop. That's when the pop. So essentially, yes, from a super hyper technical standpoint, you could say he was exiting the vehicle. Of course, it was, number one, not voluntary, it was involuntary, and only for a fraction of a second before the gunshot went off.
And of course, the statute says committed or had committed a burglary, right?
Either had committed or was in the process of doing so, and that's what would trigger this presumption. So we don't have a clear break in the action here. This case is totally distinguishable from the Heckman decision, the second district case that they've cited. In that case, the alleged victim had voluntarily extricated himself from the situation, had walked out of the garage, which was the dwelling, was basically in his car, and 15 feet away in the driveway, and the defendant in that case shot him in the leg. This is just completely different. We have the alleged victim physically struggling with the petitioner at the time the aggravated battery occurred. So the danger created by his conduct was still active. It had not dissipated. Not enough time for a human to recognize that there is any kind of retreat. I don't even think it's fair to call it a retreat if you're being pulled out involuntarily after you've already broken away once and come back. And again, very clear on direct and redirect of Mr. Fry, who's the only person who testified as to this point, that it was simultaneous, that the grab around the waist was simultaneous with the gunshot. So not enough time for any person in the petitioner's position to recognize that any kind of retreat was occurring. Now, the other basis for the trial court, other than the one Judge Thomas has already brought up, which was the accidental nature of the shooting, the only other basis the trial court provided for denying the motion was that the alleged victim didn't have a weapon. But again, 776012013, there's no prerequisite that the attacker be armed with a weapon. And I cited several cases, one from this court, where self-defense cases where defenses were asserted successfully and the defendant's discharged. The Bacon case, this court's case from 1975, where the defendant stabbed an unarmed attacker, and this court remanded for his discharge, holding he acted in self-defense. 7760113 provides that if a forcible felony is occurring in a dwelling or an occupied conveyance, that triggers a presumption of a reasonable fear that you are going to suffer death or great bodily harm. And that was triggered here when the alleged victim dove into the car without consent or justification. And very, very critical, Officer Maltese testified at the hearing that there was absolutely no evidence whatsoever that the petitioner threatened the alleged victim with a firearm prior to him diving into the vehicle. I'll reserve the rest of my time. Thank you.
Good morning. May it please the court, counsel. My name is Tom Duffy. I represent the state in this case. There were two principal findings by the trial court. The first was that he claimed accident and not self-defense. And yes, Judge Thomas, we maintain that for this law to work in the way I think the legislature intended it to work, you can't have it go off on some sort of hybrid excessive, I used some force, but not as much force as I thought I was using type of
The
scenario.
problem I have with that argument is that, under your theory then, if the defendant had said, oh yes, he came in and I shot him in the head as occurred here and killed him, he was committing a forcible felony, and you would say in that case then he would have a right to immunity, right?
If that's what the facts showed at the hearing. If
Right,
he-
but I mean, that's the law, right?
Yes, that's how I read it, and I think that's the best policy that you can make there, is that if you get into some sort of splitting hairs about who did what and how the, this accident,
But here the defendant testified, I hit him with a gun, right?
he's testified I hit him with a gun and the gun went off accidentally. I have some questions in my own mind about exactly how you hit somebody with a gun and the barrel hits him.
I'm not sure that's relevant, though.
It's not. I was about to say, that's a question for the jury, which I think is what...
No, I respectfully may disagree. If he hits him with a gun and the gun discharges, that's less culpable, in a sense, less volitional than using the firearm to shoot him.
I agree. It seems counterintuitive, but I believe that is the way the statute was intended to work, was in cases where it's not equivocal and where there's some unequivocal action. But irrespective of that, we prevail on the judge's other finding, which was that the force was excessive. Counsel read from the transcript, and again, with brief time, I hate to as well, but he ignored the lines right above that, on lines 14 and 15 on page 37. He said, question, were you trying to pull him out? Answer, yes. That's developed further at pages 47 and 48, which on cross-examination, question at line 15. Okay, now, was he in the process of withdrawing from the car at the time you heard the gunshot? Answer, yes, sir. Then over on the next, well, I don't have the next page, but that testimony is essentially repeated on the next page. And that's what the judge found.
But I mean, at the next page, he says that him and Hare, for a very brief moment, they wrestled.
Right.
I guess Charles was like Pop at the same time the gun went off. He was like that. Okay, question, line 12, page 48. So you believe he was in the position that you were describing and withdrawing from the car at the time that you heard the gunshot go off? Yes. I mean,
he was withdrawing from the car at the time the gunshot went off. And those facts...
You think under the stand your ground law that a person could commit a carjacking, be in the process of trying to assault the victim inside the car, and then if he changes his mind and starts to withdraw from the car, the occupant of the car doesn't have the right to use deadly force?
Yes, I do.
I don't see that in the statute.
Did he change his mind, or did his friend change his form?
I don't think it matters in terms of...
And so far as withdrawing, as far as that question.
Well, I don't think the victim's intent here is relevant. I think what's relevant is there some danger that the individual who does the shooting, the defendant in this case, or the individual who does the defending, is he still in danger? And in this case, the danger was dissipating. Also,
did he know that? I mean, I thought from the testimony it was like coincident to.
Well, he was being pulled backward at the time, and that's what the trial court found. And there's competence.
Mr. Duffy, let me stop you. You're talking about excessive force. The statute doesn't seem to have that in it as I read it. That
No,
when you invade a home or you invade an occupied vehicle, that presumption comes in and they may use deadly force.
That's a presumption.
Yeah, right. It doesn't say anything about excessive or anything like that.
It does
Now,
not.
we may not like the statute, but I don't see anything that mitigates when when they use deadly force, when the guy comes in the vehicle unlawfully and triggers this presumption.
Yes, it's a presumption, but like any presumption, it can be rebutted by evidence. And the evidence in this case shows, as the evidence did in Heckman, that you can't just use this law as an excuse to shoot somebody. can a police officer, this is a rhetorical question because I know you all know the answer, can a police officer shoot a fleeing felon? He cannot. Why would this, do you think the legislature intended to give private citizens
Well, the whereas
more
clauses,
power?
the whereas clauses are pretty clear about the intent of the legislature in terms of giving law-abiding citizens a right to use deadly force. I mean, it seems to me that this is essentially analogous to a carjacking or some similar type of offense. It's definitely, well, let's try it this way. Would you concede that the person who was killed committed a burglary?
Hyper-technically, yes.
Okay, so he committed a burglary. That's a forcible felony.
Just as somebody who cuts across my yard commits a trespass.
Well, counsel, I mean,
There's also some evidence, and the trial court found, or tiptoed around this, but sort of seemed to find it, that what he was doing was defending himself. He saw a gun in the defendant's possession, and he went after it. So that's why I think the
under this statute, you don't have the right to burglarize an occupied conveyance to steal a gun from somebody, right?
nor do you, in our position, have the right to shoot somebody who's no longer a threat to you, or is not becoming a threat.
Because let's try this. We know for a fact he was still in the car when he was shot, right?
Apparently so, yes. He bled all over the driver, as the testimony showed.
So, and we know essentially, I mean, I've reviewed the transcript in great detail. We're talking seconds.
Apparently so, yes.
mean,
He said, I believe on page 37, it was like two or 3 seconds.
And in
But
fact,
2 or 3 seconds, you can drag somebody a ways in 2 or 3
And
seconds.
in fact, the testimony was that the person shot spent about 8 minutes at the car.
Yes, that was the only testimony as to time limit, or the time that it took, 8 minutes. Everybody else's story, though, that seems like it may have been an overestimation on the part of Mr. Jones, I believe
So
it was.
in your
But
view, and I don't want to...
I think the trial court did find 8 minutes.
I'm not trying to make your argument, but in your view, then, if a person commits a carjacking and is inside the car assaulting a victim, changes their mind and is halfway back out of the car, retreating from the offense, so to speak, and the person inside the car shoots them, they can be prosecuted under this act?
I think a trial judge reasonably could find that after holding the kind of hearing that Peterson asks for.
You don't think as a matter of law that the person would be entitled to immunity?
I do not think so, because I think if you're going to give immunity, if you're going to take this out of the hands of the jury system, the system of laws we've lived under for 200 or more years, as every trial judge says when he's instructing the jury, if you're going to do that, you've got to have ironclad facts, and you have to have a carjacking. This wasn't a carjacking.
That's not what the statute says, is it?
I know that, but that your position is your job is to construe the statute reasonably. Otherwise, citizens have greater rights to shoot people who have committed but are now withdrawing from a felony.
Did the trial court base the decision on the fact that he was withdrawing, or on the fact that they used excessive force?
Both.
And that it was then that they claimed accident?
All three, really. I mean, it's all part and parcel of the same thing. The force was excessive under these circumstances, and I think that is the presumption that arises here. One brief point about Heckman. In Heckman, the second DCA used the term was withdrawing from the garage. The guy was outside the garage. So in Heckman, they said you don't get a license to shoot just because the guy has technically quit burglarizing your house.
What if you don't know he's withdrawing? What if he's still there and he's stepped back a step and he says, oh, I was withdrawing, but in fact, he's still there?
Well, that's for the trial judge to judge the credibility of the witnesses. As the Peterson, is it Peterson? I'm drawing a blank here. The other
Peterson's our case.
Yeah, as the Peterson decision implies that if you're going to have fact findings, obviously you're going to have to judge credibility. So that would be left up to the judge.
Judge, would you mind giving him 2 additional minutes?
No, and we'll give the other side more time to everybody.
If you don't mind, we're going to give you some additional time here.
Oh, that's okay.
I think it's a very important case. The the judge below said, additionally, this is the bottom of page 2 of her order, because the victim had no weapons and was exiting the car when the defendant shot him, the court finds the force used by the defendant was excessive. Now, my question to you is that legally relevant under the stand your ground law?
I think it's legally relevant as regards whether he's entitled to the presumption. I think that's where that comes in. It's not an absolute open season on anybody who burglarizes your car, that you can get the presumption if somebody gives you the immunity, then obviously you have met that presumption. In this case, law enforcement, and apparently law enforcement or state attorney's offices, though apparently under the statute contemplated as the entity that grants the immunity. We had a kind of an odd thing here.
But the statute doesn't say anything about the quantum of force being a condition precedent to the presumption arising.
It does not.
And that's
the presumption,
where I sort of have a problem with your argument, Mr. Duffy, is how we can take a plain statute, whether we like it or not. And I think there's a lot of people didn't like this statute. It was called an invitation to the OK Corral, I think, in the press. But that's the way it's written. So how can we now come in and rewrite it to say that excessive force is a condition precedent to the immunity grant?
I didn't say a condition. I didn't say a condition precedent. I said that's one of the factors a trial court can consider in whether the presumption that you needed to use excessive force, because that's what we're talking about here. Under certain circumstances, it's presumed that you're in danger. But it's a presumption. It's a presumption. All presumptions can be overcome by evidence. And in this case, that's what we can contend happened. It's a developing area of the law. Judge Dempsey, like Mr. Bauer and I, did not have the advantage of much in the way of case law to go on with this. But I think when you're going to take something away from the jury, you want to be absolutely sure that that's just. And under these circumstances, this isn't a carjacking. This isn't somebody burglarizing your house and, you know,
But it is a burglary of an occupied conveyance.
It is technically a burglary of an occupied conveyance.
It is a burglary of an occupied conveyance, which creates a presumption of a reasonable fear.
Which can be overcome by circumstances.
But I don't understand how there's any evidence to show that the defendant here didn't have fear. I mean, the fact that the alleged perpetrator, the alleged victim was withdrawing,
well,
how does that show that the other person doesn't have fear? He
had a gun and the other guy didn't. So, I mean, he basically shot an unarmed man in the head at point blank range. Now, what was he doing? If we were going to get into the facts, let's get into them. He's leaning into the car across somebody else, grabbing at the defendant. And the defendant swings at him. Now, you could argue that, okay, he's committing a burglary and yeah, I punched him and I had a right to. But I don't necessarily think in all circumstances this law operates to automatically. And I think that's what the kind of the thrust of this argument has been, is that it's automatic, it's triggered. But you found in Peterson that there are factual determinations to be made, and that by using the term like presumption, the legislature presumably knew that there is a huge body of case law around presumptions. And that body of case law indicates that presumptions are not automatic. They're not conclusions. They're only presumptions.
Thank you, counsel.
Thank you very much. Well, let me just say we ask that you affirm the trial court.
Do I get an extra?
4.5 minutes. Yes,
Okay. Thank you, Your Honor. First, let me point this out. The state suggested in its argument that the judge found that the alleged victim dove into the car because he saw the gun and was trying to protect himself. She did not make that finding. Throughout the hearing, the prosecutor attempted to elicit opinion testimony from the various witnesses saying, why do you think he dove in the car?
Well, let's look at the facts in the light most favorable to the findings in the state, since they prevailed. Although I would ask if what you think the standard of review should be of those factual findings, but assume he dove into the car and was being pulled back by his friend. And as he's being pulled back, your client shot him. You think he's entitled to immunity in that situation? I don't think there's any dispute that he was being pulled by his friend. That's your own witness.
I think if it would have been clear to any reasonable person, and had it been clear to the defendant that the danger had completely dissipated, maybe an argument could be made that he would not be entitled to immunity. But the only testimony on this point came from Ron Fry. And he said over and over again, 10 times probably between the direct, the cross, and the redirect, that only 2 to 3 seconds elapsed from when the alleged victim dove into the vehicle to when the gun went off. So, you have to have reaction time. You've got, Mr. Fry reaching into the car to grab him and pull him away. There simply could not have been enough time for there to be a clear break in the action where the danger had dissipated, like in Heckman, where the guy had walked out of the garage 15 feet away next to his car in the driveway. It's a completely different situation, and I just want to make this point. The judge found in paragraph 7 of her order that it is unclear why the alleged victim dove into the car. She did not find that he dove into the car because he saw the gun or because he thought it was necessary to defend himself.
But, it's really irrelevant, isn't it? He committed a burglary, he dove into the car.
True, but I
asked your opposing counsel the question about carjacking. To be fair, I'll ask you a somewhat different hypothetical. Someone's in traffic under this law, and a road rage incident occurs, and the person behind them, they're stuck in bumper-to-bumper traffic, and the person behind them comes up to the car, reaches in to punch the driver. That's a burglary, right?
It's a burglary with assault with a PBL, I guess.
Right. And in that situation, your argument is, under this law, if there's a passenger sitting there with a firearm, they can shoot the person committing the road rage burglary.
Because it's an ongoing forcible felony that would trigger a presumption that death or great bodily harm is going to be visited upon the occupants of that vehicle. And the state's trying to make it out that this will apply everywhere. People can roam the streets and just shoot people. This presumption only applies in the cases of dwellings, residences, and why it has to, who knows, and then occupied conveyances. Just to those situations, the conveyances are treated differently. That's why, again, it would be a life felony. Just pointing a gun through a window at someone, not even hitting them, that's a life felony. That is a forcible felony, even a nonviolent burglary. I cited cases in my petition. There's a 3rd District case holding that nonviolent burglaries are forcible felonies, and this was a violent burglary. He dove into the vehicle and was physically attacking the petitioner. The petitioner testified that the alleged victim was trying to grab him around the neck.
But that testimony doesn't have to be accepted, and I don't think the trial court did.
Well, she said they were tussling. She didn't reject it. Her problem with her order is that her findings of fact were pretty limited. It was one paragraph in terms of after leaving the club to the shot in the forehead. I'm looking here, 12 lines. She spent almost as much time basically implying that the Vasquez decision is preferable to the Peterson. It would have been more helpful if we had greater detailed findings, but she didn't reject that testimony. But she did find that there was tussling, that there was a physical struggle. And that's all we need. The defendant did not initiate this encounter. Officer Maltese, the homicide investigator, testified. He interviewed everyone, and he testified at that hearing. And if the state wanted to bring other people in, they could have. They didn't call a single witness at this hearing. We called everyone. We put everything out there for the court.
That's your burden, right?
It's our burden, but we could have been selective. We could have just called Mr. Fry. We could,
Speaking of your burden, will you tell us your view as to the standard of review we should apply here?
Well, I think her factual findings is sort of an emotion to suppress. I think if the findings are supported by competent, substantial evidence, then those findings were stuck with them in terms of her conclusions of law. That's de novo. So I think we look at what are the facts that we have here, and I think we win under the trial court's findings. The only problem I have with what the trial court found was, well, he was exiting when the defendant shot him in the forehead, but that's a very truncated, incomplete description. First of all, for her to find that, she must have believed Ron Fry, because he's the only person who testified on that point. And if you're going to believe Ron Fry, you have to go with his testimony. You can't just pick one sentence out of the cross-examination where the prosecutor asked the leading question, well, isn't it true he was exiting? Yes. Well, that's not the whole story. You have to read the 10 pages of testimony. It was only 2 to 3 seconds. He said that over and over again. And Mr. Fry made it quite clear that the shooting was contemporaneous with grabbing the alleged victim around the waist and trying to pull him out.
What about her finding that of the use of excessive force?
Well,
Would
excessive-
you argue that that wasn't a requirement of the statute?
Right. Either he was entitled to use force or he was not, and he was entitled to use force. It's not too much force, and again, he didn't...
How would you say that that's not even an element of the statute, as Judge Browning has pointed out?
Yes. I mean,
Excessive, whether it's excessive. or not.
there is no conception of it excessive in the statute. It's did he have the presumption? Was the presumption triggered? If it was, he met his burden, which was only a preponderance of the evidence. Thank you.
Thank you. Thank you, counsel. That concludes